check all our settings after we get going.
Yep.
We're recording, we can pause. Get everybody in.
Okay, thank you for coming tonight. We've got about 40 plus people here. This is Mayor Larry Jacobs. I'm in Town Hall with Committeeman Doug Stevenson. And tonight is our March 30, 2021 meeting. This is where we are going over the BHHC litigation concerning the declaratory judgment on the recapture fee. This is a little bit of a redo and an update from a previous meeting we held. At that time, we had a Zoom limit for 100 participants. We have since increased to a 500 limit of participants. I don't know that we'll hit that limit tonight. But what I want to do is I want to start off the meeting with Sal DeFazio, who is running the litigation concerning, once again, this is a litigation on the declaratory judgment on the enforcement of the recapture fee. And we also are joined by a few other Township Committee members who are attending remotely, and also to assist and support Sal on any questions is Heather Mahaly from CGP&H. So Doug, unless you have any comments, I think we'll turn it over to Sal.
No, I think that's right. I think that for those of you who attended the first session, this may be a bit duplicative, but we understand that not everybody could get in. So we said we'd do a second round, and this is what this is it. So I agree. Sal, why don't you take it away?
Sure. Good evening, all. Those of you who may have been on the first call will be reminded that during that call, I promised to file a stipulation clarifying the fact that the litigation seeks nothing more than the recordation by judgment of the already existing lien and obligation for the payment of recapture fees. That stipulation was filed, waiving any claims for attorney fees, costs, or monetary damages of any kind. I am here to answer whatever questions I can, subject to certain constraints. You all need to understand that I represent the BHHC in this litigation, and I cannot give any of you legal advice, but to the extent I can answer questions, I'm happy to do so.
Great, Sal. My name is Richard. I have a question.
Hi, Richard.
Hey there. I just wanted to start off by stating for the record that there's a large sum of money in the Bedminster Trust account. My understanding is that there's over $1 million. I also have an understanding that our operating account has over $600,000, and I understand the BHHC is set to collect roughly $800,000 from uncollected recapture fees as a result of this lawsuit. My first question is, can you confirm that, or can anyone in on the council confirm that those figures?
I cannot. That's not my bailiwick, but perhaps Mayor Jacobs can confirm the amounts there. Although I don't know how that's germane, but Mayor Jacobs?
I don't have those specific numbers. I think we did have them at the last meeting. There are a fair amount of funds in the what had been the BHHC accounts are now in the Bedminster Affordable Housing Trust Fund. So those monies are sitting in a special account set up within Bedminster. Those are devoted to the Affordable Housing Trust. Richard, I don't have the specific numbers. I can't tell you if those numbers are right or wrong.
Well, we can say the turnover from the turnover from BHHC to the new administrator and the placing of the funds in the account that did happen. Mr. Seco did turn over the checks for all the existing accounts. So
It's my understanding that those funds are, designed to improve our community. I just wanted to say for the record, I live in Cortland and I don't think our sprinklers have been turned on for roughly 7 years. So it's extremely concerning to me that, we even have to meet here to discuss this. But I have 4 questions for you today. And it's based on the changes. First, does CGP&H meet with sellers before putting the home on the market to counsel them?
I don't know who you're asking that question of, Rich. I do not
Anyone-
represent, Rich, may I finish? I do not represent CGP&H, and the purpose of this meeting is not to discuss the processes going forward with respect to CGP&H vis-a-vis the prior processes of operation utilized by the BHHC. This discussion is pointed to one specific area, and that is questions concerning the pending declaratory judgment action litigation.
Okay, here's my next question. Do you
All
qualify
right,
buyers?
Richard, before you proceed, since this is a public meeting, we don't take anonymous questions. So you gave your first name, but we do also need your last name.
My last name is Saccone. I live at 101 Cortland Lane. I just turned my camera on. I'm sorry.
Okay.
My second question is, do you qualify buyers before showing the home?
Again, that has to do with the process, not with the litigation.
Richard, if you are selling a home, you should be reaching out to CGP&H to initiate that process.
Okay, so that's 2 questions I've had that you guys have failed to answer. Here's my third question. Will CGP&H be the ones showing the home?
Richard, are you selling a home presently?
That's none of your concern, but can you answer my question? Will CGP&H be the ones showing the home, or will I have to do that myself if I choose to sell my home?
Mayor, again, I can't answer that. That was not my understanding of the purpose of the meeting. So I don't know how to answer.
Well, Sal, there's been a whole mess of folks that are trying to spread some stories out there about what CGP&H is doing, how they're managing, and certainly in comparison to BHHC, or at least what they thought BHHC was doing. Mr. Saccone, if you have specific questions regarding showing your unit, assuming your unit is in restrictions, you should direct those questions to CGP&H directly.
So the litigation was not the purpose of the first meeting, but regardless, now you've had 3 questions you failed to answer. I have a 4th question. Who negotiates and writes the contract? Is it me? Or will I have to pay for that?
again, Richard, this is not a question that's germane to the proceeding tonight. If you have questions like that, please feel free to take it up with CGP&H after the fact.
I think everyone on this call is interested in the answers to those questions, and it's really disappointing to see the leaders of this community preying upon our poorest members. I just mentioned that you guys have millions of dollars in various accounts. We received knocks on our doors on Christmas Eve from the constable, giving us a lawsuit. Can you answer some of these questions for us, or provide services where we can get them answered? Because this is absolutely critical if I'm to be able to determine the best course of action moving forward for myself. And if you want my honest opinion, I think it's really ridiculous that you guys are skirting around these issues. I think this is the crux of the matter, and really why I has chosen to join today. There's a bunch of people interested in this, and I'm really disappointed in my town's leadership right now.
Okay, Richard. Well, thank you for your questions and comments, but that is, the purpose was set up to discuss the declaratory judgment. The process that CGP&H is operating is the process that was in place beforehand. You may not like that answer. You may think that there was a different proceedings going on beforehand, but that is not the case.
Well, you guys are selling unqualified home buyers to prospective sellers, and it's ridiculous because you're wasting their time because they can't buy the home. So Who's going to fix this?
Well, that's why we were suggesting to you that if you're in the process of selling your home, to reach out for CGP&H to make sure that you're coordinating your efforts and not wasting your time.
My understanding is that the woman who runs that program lives in Pennsylvania. Can you confirm that?
How is that at all relevant to what we're talking about today? Come on, let's stay on point.
Because she's not going to help us when we try to sell our house. She's supposed to walk us through the process. She's supposed to help us show the home. She's supposed to help us write the contract. And my understanding is that none of those responsibilities are going to be handled by CGP&H, and now the onus is on the homeowner.
BHHC did not draft contracts in the past.
Yes, they did.
BHHC did not show homes. The CGP&H representative met with the BHHC executive director as part of the transition, and they went through all this. So Richard, I appreciate your comments. And once again, if you have a specific question regarding selling your house, reach out to CGP&H and they'll walk you through that process.
Oh, it says mute.
If anybody agrees with me on this call, I'd love to hear some support. I understand that there's other people interested in speaking, so I'll relinquish my time, but I'd just like to, and I'm extremely disappointed that you guys chose to do this in the Forest community. The President of the United States used to live in this town. I find no reason that we can't coexist peacefully with an affordable housing program. It seems like we're under attack.
Richard, thank you for your comments.
This is Marilyn Graham. Can you hear me?
Yes.
Hi. My brother, my sister-in-law, and I bought an affordable, I bought market value condominium this past December.
Margaret Brown?
And we were, the third purchaser of this property. And we were served, with papers as far as recapture fees. So my question to you is, why were we served and we weren't the first owner?
So my understanding is that you're saying that you are the third purchaser after the unit was no longer under restrictions. Is that what you're saying?
Yes, that's true.
Okay, has the recapture fee that was owed on the first sale after the cessation of restrictions ever been paid?
To my knowledge, no, because it was Mr. Icknock that owned it, and he filed a lawsuit and won, and so he was absolved of paying that.
Well, no, that's your understanding of the lawsuit and its result is not correct. You should feel free to have counsel call me, and I'll be happy to provide them with a physical readout of the judge's decision, the actual decision itself. Here's the problem. What I can tell you is that the lien of recapture fee is what is known in the law as an in rem lien. It runs with the land. Therefore, theoretically, whether you're the second owner or third owner, if you bought a unit and the recapture fee was not paid, that lien still exists as against the property.
It was never disclosed.
Listen, whether it was or it wasn't is not the issue. That's a separate issue for a separate time. But I would suggest to you that you own a market value unit, correct?
Right, and we bought it at market value.
I understand, and you're not in affordable housing. So my suggestion is that you have your counsel contact me, and I will walk him or her through the steps.
My counsel is Karen Spano, and I believe you've spoken to her.
I have.
So what else does she need to do?
There's nothing that she can do at this point in time to resolve that problem. There is potentially a methodology by which it will be resolved, but I don't think I can go into that at this point in time.
Okay.
Marilyn, this is Joe Grum. Marilyn, let me jump in and ask Sal a question. So Sal, we bought this unit 4 months ago, okay?
Right.
And it was after the 30-year recapture period expired. I believe it was in 2017 of August it expired. So my question is, why are we named in the lawsuit?
because your property still has a lien against it.
Why
Okay.
wasn't that discovered in the title search?
That's a question for your title company, not for me.
Who has a lien on the houses?
So, folks, let me just jump in. The creation of the recapture fee obligations, you'll note them in each of the associations. There's a document called the Declaration of Covenants and Restrictions. We call it DCR. That's recorded in the land records, and it was recorded back in the 80s when your particular development was fully built out. And units as they transact are all subject to the recorded DCR. So the obligation exists of record in that DCR document. The question that you have or that you should pose to your attorneys and or title companies is whether they reviewed the DCR in connection with your purchase. So it's not going to be in a deed. It's not going to be a separate disclosure. It's within the organic documents that create your development. This whole plan was put in place by the developer as a means to ensure that the recapture fees are being replenished. So just so you're aware, if you're in the Cortland neighborhood, you want to look at the DCR for the Cortland neighborhood, and you'll see those requirements.
This one is Parkside.
Okay, so the Parkside has a Parkside DCR. And that's, again, it's recorded of record in Somerset County. And all of the deeds that transact in that neighborhood are subject to the terms, restrictions of the DCR.
And
All right.
all of the deeds, the DCR for each of the four affordable housing developments has identical language.
Okay.
Excuse me,
Why
My
did, one more question. Why didn't the association, when they filled out the application we had to pay for, let us know about it?
I certainly can't answer that.
Well, wouldn't that be their responsibility? Okay, to say, hey, you know what? There's a lien on this property.
Again, I can't answer that.
Hey, to clarify, the association.
Who's speaking,
isn't-
please?
Sure. My
Who's-
name is Alex Crosset. I'm the property manager for Parkside. The lien and searches of that nature, like Sal and like the township are referring to, really show up with the unit. And that's part of a sale transaction of each individual unit. It doesn't have anything to do with the general administration of the association. It's a contract between you and your purchaser, or those parties involved. So that's why that doesn't show up here. Really, the clearinghouse for that is with the title company. I did have my hand raised for some questions, but I don't want to cut you off. I'll wait for that.
Can I
All right.
just clarify something that was previously said?
Mhm.
Who's speaking, please?
Danielle Melissa, 57 Hyde. I heard you have someone with a similar issue to me where the lien moved with the seller, or with the buyer, I'm sorry. And you said that their attorney needs to contact you guys in order to discuss what was going on. And when she mentioned that she in fact has contacted you guys and she asked the next course of action, I believe it was stated that there's nothing else she can do. Is that correct?
No, that's totally incorrect.
Okay, so can you please clarify?
I don't know which attorney you're referring to. I've spoken to probably 50 of them.
Well, somebody here today had just asked you.
I
If-
actually spoke to Ms. Spano today. I don't know if it was on this particular property. It may have been on another one. And I've spoken to her multiple times before. And it's not that she was told that there's nothing that you can do. The unfortunate reality, though, is that the lien continues to exist. And that lien will exist until it is resolved one way or another.
Okay, thank you for your clarification.
Now, this is Joe Grom. So that lien continues through the 30-year retention period. Is that a recapture period? Is that correct?
No, that lien continues through the 30-year recapture period. And until such time, so you have to understand, folks, if you're in the, and I use your language and that was my mistake. I should have said the lien exists through the 30-year restrictive period. And then the lien continues to exist until the first sale after the restrictive period has lapsed, when the recapture fee is paid. So let's say a house went on the market during the restrictive period, CGP&H will be calculating the recapture fee as part of the approval process for the sale to a new affordable purchaser. You all understand that. The problem that develops is when, after the restrictive period has concluded, you're selling at market value. CGP&H is no longer involved in that sale. So your title company has to pick up the lien, or your counsel, and if they don't, and the lien isn't satisfied, it continues to run with the land, with that particular unit. That's our position.
And Sal, can you just explain how what you're working on is designed to address that issue, and so that this is not missed into the future?
Okay, we are working on this problem on two fronts. The BHHC's declaratory judgment action is intended to accomplish two things. First, it is going to reduce to a judgment the existence of the recapture lien obligation. You understand that? Right? Secondly, by filing the declaratory judgment action, we essentially mitigated any further losses due to the failure to pay recapture fees, because now that a lis pendens is on the property, and once a judgment replaces that lis pendens, everybody who goes to sell and their title companies will absolutely know of the existence of the recapture fee. On a secondary level, not germane in particular to this conversation, is the fact that I am handling litigation against counsel, prior counsel to the BHHC, who had rendered an opinion which essentially triggered this problem. And it is my hope and the township's hope that when we prevail in or resolve that litigation, that what will happen is that the proceeds of the settlement or judgment in that litigation will essentially resolve any outstanding indebtedness on the behalf of people who still have a lien against their property because they bought it without knowing about the recapture fee. Do you understand that?
Hey, Sal, it's Larry Jiggs. What we're going to do for a second is we're going to just take a brief moment because we got folks who are supposed to be muted. So we've got multiple people talking at the same time. So I'm going to ask Robin Ray, our town administrator, to mute all. Then she'll unmute Sal. And then she'll call on each person who's raising their hand, like they're doing. And when you are called on, please give your full name and address. So now to Sal, and then
I'm
just,
here.
Yeah, he's here.
okay, and then just, okay.
Okay.
So now, Robin, you'll just go through one at a time.
A lot of hands.
Hi, thanks for unmuting me. My name is Alex Crossett. I represent the Parkside Association as their manager. My address is not in Bedminster, but to state it's 21 Meeting House Court in Chemung. A couple of clarifications, and I'll start with where Sal just left off. So I understand the lien traveling with the unit, and it kind of answers a question I might have phrased differently before, but I was curious as to why the BHHC was not pursuing its right to these recapture fees, previously in this manner, because then it would have always been captured. And furthermore, and I understand this is just the nature of how the filing was done and that perhaps it was a bit more streamlined, but this almost subrogates the responsibility for that fee payment. You know, and I understand the complications of title companies who did not clear, brokers, attorneys, buyers, sellers, anyone involved in the sale, then, that this wasn't collected on. But essentially what some people are now put in the position of is, to my understanding, that now since this fee is out there, it's with their unit. They own it now, but may not have had prior, any responsibility to be the person who actually pays for it. Are they to now pursue their title companies and their attorneys? And is there, basically a countersuit that then they would have to go against them? Because then that puts a huge burden on, current owners. If they have to go back in time to when they sold their home and have this type of argument with the buyer, the logistics of that, let alone the cost and any other concerns are huge. And I know there's
Alex, that's a good question. And the best way that I can answer it is as follows. The force and effect of the declaratory judgment action does not change anything about the status of the lien with respect to any individual property owner's property. You understand that? This litigation does nothing more, the declaratory judgment action does nothing more than reduce to a judgment which will be discoverable on Charles Jones searches by title companies that the recapture fee is or may be owed. You understand that?
Yeah.
Okay. So whether in this litigation, frankly, again, I have to be careful because I don't want to be accused of giving legal advice, okay? But what you're suggesting about contacting all those people and taking all those steps is not, in my opinion, ripe at this point. With respect to this litigation, it really is irrelevant. Because whether they knew or didn't know and whether somebody else was responsible doesn't change the underlying issue of the case, which is simply the lien is valid and it's being reduced to a judgment, so it's discoverable. It was always valid. If somebody in your development goes to sell and they are confronted with the lis pendens and the fact that they may have to address the fact that a recapture fee was not paid by the first owner after it came out, I will talk to the township and talk to the CGP&H and the advisory committee. I have some ideas about how we can address that to try and reduce the pain. But the reality of it is that if somebody now who owns a unit goes to sell it and that unit and the prior owner did not pay the recapture fee, that recapture fee is going to have to be paid by the present owner.
So Alex, let me just jump in here because you're touching upon an issue that we thought about as well. We're aware through, anecdotal stories. I don't have any firsthand personal knowledge, but I understand some folks who have purchased at market rate. As part of their closing, they did a side escrow with the title company and the amount of what the recapture fee would have been. This first step from my perspective, if you're in that situation, would be check your closing statement to see if there was an escrow created for that liability and that obligation. Some folks may have that. If there was an escrow created, you work with Mr. DeFazio to release the escrow, then that obligation would be released from the unit. So this is not a situation where BHHC or the successor is looking for double payments here. Just look at what was happening was that units were transacting because this obligation was buried within these DCRs. No one was picking up on it. So you do have a certain number of transactions that sold and the recapture fee was not paid. But at least in that subset of cases, I think that there were instances where an escrow was created.
Surely. So that will make sense and that clears some of that up. My only other question, and I don't think has been addressed and might be in this venue is, another concern amongst some of the residents and owners, especially those who are familiar with really what the BHHC and now CGP&H is meant to do for their communities and meant to do for them as homeowners is that, lawsuits can be expensive. is this to be funded from the current BHHC pot in pursuit, understanding that that other judgment, if successful, may replenish some of the recapture fees? Because there is a concern that we'll reach a point where we're basically trying to sue ourselves and then we're going to negate any money we would have gotten from these recaptures. Like, is this, what does that picture look like? You know, are you draining the BHHC funds?
I can answer that question. The amount of money that has been spent on fees and costs necessary to accomplish what we're trying to accomplish here for the benefit of affordable housing is a fraction of what we expect to recover in the companion litigation and to recover by virtue of resolving this ongoing bleeding of the lack of recapture fees. In addition, the companion litigation has a claim for fees that were paid, in my opinion, on prior efforts by former counsel, which we're seeking to get recover in that litigation. When all is said and done, if we recover that, we will likely wipe out probably close to half of the cost of this litigation and then collect over $1 million potentially in recapture fees. So I understand your concern. And I can tell you all that anytime I take on litigation, I always represent to my clients the importance of economics. And in this situation, the economics of going forward and being successful or resolving that case and this case far outweigh the detriment.
Sure, and that would be ultimately, you know, in further service of the affordable homeowners, being that it would, you know, fill the bank up to whatever degree, you know, it does. With, okay. Okay, great. Yeah, that's all I have for now. Thank you for answering my questions.
You're more than
Okay,
welcome.
there's something I do want to point out for those who are participating on this call by phone, and you don't have the Zoom option of raising your hand, *9 is how you can be put in queue to ask your questions.
Hi, I'm sorry, let me put my camera on. Hi, my name is Kristen Beluzzi. I own 27 Kensington and Parkside. I'm one of the people that purchased at market value, and the lien is following me now. So I kind of understand what's going on. I'm just unsure of how to respond to the litigation. I understand there's something about a stipulation that may need to be filed in court by an attorney on my behalf.
The stipulation does not need to be filed. There is a stipulation posted on the township website, which you are capable of filing yourself.
Okay.
And submitting to a specific email address at my office. And those stipulations simply say that you understand that the declaratory judgment action is simply to codify what already existed, which was the lien of the recapture fees. You don't want to contest, you're not contesting, but you want to be kept apprised of the developments in the litigation.
And Chris, this is Mayor Jacobs. I believe the form stipulation that Sal mentioned was it on our website or was it here?
It's on our website.
It's Del, you want to
it's on
describe
our,
it where it is?
It's on our website, but Chris, I don't know whether the stipulation is for you, because the stipulation essentially, it was created, and just to give everybody context of why that's there, we on the TC in the township understand what this is, this disruption to you guys. We get it. Unfortunately, it's a necessary disruption. So what we were, listening to the complaints and suggestions by folks is what was going on, that they don't have time, they don't have the money to, speak with an attorney. And so in an effort to minimize any, what's the inconvenience, we'll call it inconvenience to you, that, we came up with a stip that basically says, I've received the summons and the complaint. I acknowledge that there's a recapture fee. I understand that there will be a judgment issued. And I wish to enter my appearance to acknowledge receipt of the summons and the complaint, but I don't wish to fight the relief that's being sought. And that was our response to streamline your ability to get notice of the proceedings, to understand what's going on. But if you have a dispute, or if you think that there's an issue that you shouldn't be subject to the judgment, that stipulation is not for you.
Okay, so what is for me then? Because from what I'm understanding is someone was at fault here. It was either my title company or the BHHC that they did not disclose whatever necessary fees should have been paid by the person that I bought it from. So now it's kind of like, oh, well, it's on you now. And I understand recapture fees. I get the point behind them, but I am not responsible technically. It should have been the person I bought it from. So
Right.
I know that's not part of this lawsuit, but I don't want to accept and say, okay, I understand and accept these recapture fees
Right.
because I don't for myself.
That's right.
I do process, but unfortunately, I don't know who messed up in the process.
So the short answer is you should speak to an attorney. You don't have to.
Okay.
You can certainly appear pro se, but you should speak with an attorney to the extent you can, and explain your situation. The only thing I can say to you is, if, again, repeat what I said earlier, check your HUD statement on your purchase to see if there was an escrow created. If there
No.
was an escrow created, you may, that may be your out. If no escrow is created, then you're really in the position of what Mr. DeFazio was saying earlier, that perhaps he can work a settlement on his malpractice claim. And you would clearly be one of the parties that were, the recapture fee on your unit would be part of the damages we'd be seeking, or I shouldn't say we, BHHC would be seeking against their former attorney.
Sal, do you give an opinion, not a legal opinion, on the applicability of the stipulation to Chris's situation?
Yeah, I think the stipulation applies to her as well, because it goes specifically to the declaratory judgment action. It doesn't go to the question of whether there's third-party responsibility for the recapture fee not having been paid. She's only stipulating in this litigation, that's not going to bind her. If she turns around later, and you can't answer all possibilities. If there's a reason later for her to seek indemnification or contribution from a title company, an attorney, whomever, I don't believe it would bar her. We certainly wouldn't take the position that it does, but I understand Doug's concern. So
Okay,
the simple answer is have your attorney call me.
Okay.
And I have had this conversation with any number of people's attorneys in your shoes,
Mhm.
and they've all been satisfied and understood where I was coming from. So, and it's difficult for me. I apologize. I don't want to sound cryptic, but you have to understand that under the rules of ethics, I have to be very careful about saying anything which would constitute legal advice to you.
Yeah, and Chris, let me just also say, you might want to place a phone call to your title company. And
Okay.
explain the situation, explain that, you've been named in this lawsuit, you've been joined in a lawsuit, it involves a claim for a lien on your property. You don't believe that it's proper, and you'd like to put the title company on notice. Now,
Okay.
the title agent should help you put together a letter that you would send to the title agent, and then they would forward it to the insurance carrier to say, hey, there's a claim here under the policy. Because that's basically what they've done, is they issue you a title policy and they insure your title. The issue, just so you know, you may have look forward to, is they're going to issue a letter back saying, thanks for your claim. And then they're going to analyze your title policy and tell you whether your claim is covered or not covered.
Okay.
What you should also know is that it's not just a question of whether an escrow was created. The non-payment of recapture fees does not apply to everyone who purchased post restrictions. Some people actually paid them. I've had a couple of people who've come forward with their proofs. I've back checked with Heather, and in fact, the recapture fee had been paid. So we were able to release their unit from the litigation.
Okay, so that makes me kind of wonder, I'm assuming not everybody used the same title company, so that would make it seem like some title companies were able to extract the correct information from BHHC and other companies may have not done their due diligence.
Yeah, it wouldn't be from BHHC. It would be in the land records, in the DCR, in that document. So within your title work, you're looking to buy the property, you're the prospective purchaser, you hire the lawyer hires a title agent, then they give you what they call a title search. They run the search on your title going back to the county, and you get a big stack of documents. And included within that should have been the DCR.
Okay.
And this is Mayor Jacobs. I'll just say that, you'll get some instances where some title companies may actually have read the DCR and would have flagged this issue as something to get resolved at closing, and others may not have read the DCR, and those transactions would have gone through, and the title companies and the lawyers may never have picked it up.
And
Okay.
there's a third situation that I've come across where the title companies actually have an exception in their policy for what is set forth in the DCR. So there's so many different possibilities here. The simplest answer, especially, for those folks who are in affordable housing and they're in affordable housing for a financial reason, I have recommended that they contact legal services. For those of you who have purchased at market value, I suggest you call your attorney and have them call me.
Okay, thank you.
You're welcome.
And thank you, Chris, for those questions.
Hi, I'm Paula Schmidt. I bought 2 market rate units, one at 45 Hyde and one at 73 Parkside. So I'm in the same situation as Jennifer. So, yeah, I guess, I'm listening to everything, but my basic question is, why were my sellers not involved in this lawsuit? I didn't see Stacy Cotullo, Anthony Cotullo, or Christopher Garnecki, who were the sellers of my units named in this lawsuit. I bought them at
Because this lawsuit, the litigation we're discussing tonight, the declaratory judgment litigation, has nothing to do with your specific transaction. It has to do solely with reducing to judgment the obligation to pay recapture fees, period. It doesn't go to each and every transaction that has occurred.
And I think the point, Sal, is that you did a current record owner search for owners of units as of the date you were filing your complaint. So you weren't looking backwards. It's
Correct.
It's an obligation owed by the current owner.
Correct.
And that's what Mr. DeFazio was saying earlier. For those who are following along, this is an in rem lien that runs with the land. What that means is, unlike what you see, with Judge Judy and, all the Superior Court judges, you get a money judgment against someone. It's a personal judgment. Wherever the person goes, the judgment goes with them or has the ability to go with them. This is not that. This judgment that Mr. DeFazio is looking to get will remain against the units regardless of who owns, who buys, who sells. The lien remains until satisfied. So the issue is that, units were transacting, folks were not picking this up, the fee was being missed. This lawsuit is designed to stop that, to make sure that everybody that's looking at the title, everybody that's involved in the transaction understands and knows what the obligations are. So the reason why you don't see your seller in there, because they're not current owners.
because a mistake was made, right? And nobody caught it.
Your title company, your lawyer, yes.
And the BHCC didn't catch it. They didn't catch it. They didn't catch it.
BHHC wouldn't know.
No, the BHHC was not involved in your transactions
Right.
because your transactions were subsequent to the restrictive period ending. So as I said before, the BHHC is involved by definition in all sales purchases that occur during the restricted period because they have to qualify purchasers. They have to make sure that the recapture fee is paid. That there's a host of things that have to be done. Once the restrictions are lifted, the BHHC is no longer involved in qualifying a purchaser. The purchasers are market value purchasers. So the BHHC would not have been involved in either of your transactions.
But I thought that in the master deed, there was a clause that said that the BHCC or whatever they're called had to give notice to the sellers to remind them about the recapture fee. And that wasn't the case. They never gave notice to them. I have a letter that they sent to one of the sellers, and it just said, you know, your unit's coming out of deed restriction. If you get out, you have to pay market rate taxes, et cetera, et cetera. But that letter made no mention of, oh, and by the way, you're going to owe this recapture fee.
I'm not sure, excuse me, I'm not sure what notice provision you're referring to.
It was just a letter. Yeah, it was just a letter.
Yeah,
from.
But what you have to understand is that what you just described in terms of people not understanding their obligation to pay the recapture fee is the subject of the companion litigation.
Okay. Okay.
And companion litigation means the suit against BHHC's former legal counsel.
Okay. I guess I don't know enough about all of that, but yeah. It's just, yeah, to me, it's just horrifying. I'll be honest, I'm a market rate buyer. I derive no benefit from the affordable housing program. I never lived there. I just bought at market rate, and I'm being hit with this. It's very, very distressing, I would say. Thank you.
Thank you.
Thank you.
Is it my question? Can I speak?
I think if you're unmuted, that means that's your turn.
Okay, hi, my name is Lisa Dwyer, and I'm at 10 Cheswick Court in Bedminster, New Jersey. And
Hi,
I like to ask you a question. When these were low income, or when they were low income and then they went fair market, when I bought my unit, Sharon sold my unit to me. So now you're asking for the recapture fee. And if I have to get a realtor, I have to pay the 6% also. Back when we bought the units before, the real estate part was done by Sharon. She looked for the person to purchase your home. So now you're not just getting the 20%, you're also getting the 6% that a realtor would cost when we didn't have to pay that when we were under low income housing.
Well,
I'd like to know,
first of all,
are you going to make any kind of, well, the 20%, I'm just saying, are you going to do any kind of, you the mayor, are you going to look into that part? Because Sharon was involved in that. Sharon was the realtor for all the units back then. And now we're become 26% of our units are going to be sold. We have to give up front. I'm just asking.
Are you referencing a unit that is no longer restricted?
Yes, I'm in a no restricted unit. I have to, if I'm going to sell my unit.
If you sell your unit, you are going to have to pay a recapture fee.
Yes.
And that would go back to affordable housing to ensure that other people are given the same opportunity.
I understand that part. I'm not asking you that. I didn't ask you that part. I said about when you have to also hire a realtor to sell your unit, because Sharon was the realtor.
No, but let me finish, please. The recapture fee is solely that 20% as it is affected by improvements and so on and so forth of the difference. That goes to the benefit of affordable housing. The 5 or 6% you pay to a realtor to sell that house at market value for you, first of all, that comes off the difference between your base price and your sale price before the recapture fee is calculated. And secondly, you paying a realtor is no different than anybody else paying a realtor a commission on an open market sale.
So
You're no longer in affordable housing.
Okay,
No.
no, I'm not saying
Lisa,
that.
Lisa, you're aware that the 20% recapture fee is only on your gain? It's not on the total
I
sale price.
understand on my gain, so I'm gonna say to you, I'm gonna go I'm gonna hire a realtor now, right? Is that
Right.
money coming off of the 20% too, so that it's less off the gain? So that if I have to pay a realtor 6%, which is probably like maybe $5,000 or whatever they charge these days, that comes off the 20% too? So that would
No.
make it 50, no?
No, that comes off the difference. It comes off your gain. Let's say you bought your unit for 90,000 and you're selling it for 190,000,
Okay.
right?
Mhm.
The commission that you pay on the $190,000 sale, the gain would be the difference between 190, right?
Mhm.
190 and 90. So you'd have a $100,000 gain. The commission you pay comes off that gain before the recapture fee is calculated, as do certain other improvements. So, but the commission is an obligation for you on a free market sale, same as it would be for anybody else on this call.
So it's Lisa, it's Mayor Jacobs. So if your unit is no longer restricted, you are not going through CGP&H or any other affordable administrative agent to sell your house.
Right.
So you're just like anyone else selling your house,
Right.
except there is the 20% recapture fee that's owed upon the first non-restricted sale.
So I'm just saying that everything I do, like if the realtor cost, that will come off of the balance, so that would make it less money that I have to give as a recapture fee, correct?
And you should, and Lisa, you should reach out, if you are in the market to sell your house, please reach out to
No, I'm not-
CGP&H for those, so that they can run you through the details and how that is calculated.
One more question. I understand we got this judgment against us coming to us. How do you give a judgment to somebody without letting them know in advance? Like you guys put the judgments on our houses and then you guys, the lien against our property, and then you said, give us the judgment. Aren't you supposed to do that? Let us know in advance? Because you did that in December.
Yeah, that's why you got served with the summons and the complaint. That's your service of process.
Is the less pending on, when was the less pending put on our property though? Was it when I got served, or was it prior?
Sal, you want to just walk that through?
Yeah, sure. The lis pendens is filed at the same time as, or actually 24 hours after the complaint was filed. So the complaint is filed, then the lis pendens is filed to put you and the world on notice that there's a complaint pending, and then those things are served on you.
So you're saying that the day I received the letter, the day before you put it on my property, the day before. Is that what you're saying to me?
I don't know what you're talking about. When you say the day before I put it on your property.
When you served me, when did you put the less pending on 10 Cheswick Court?
We filed a complaint against 10 Cheswick and all the other units for declaratory judgment.
Mhm.
And then after we filed the complaint, based upon the statutory requirements, we then filed the lis pendens and served both on you when you were served.
Oh. So you don't have to give me notice way before, like 30 days or anything like that, to let me know that you're going to be putting a less pending on my property. You don't have to do that by the law. You tell me
Well,
that?
Doug, I don't want to give legal advice. Why don't you answer that?
Yeah,
please?
no, there's no requirement to give notice. And just so folks understand, the notice of lis pendens is a document that is merely a heads up. It's anybody who has an interest in your property that would be doing a review of your title. That's a document that the courts use all the time. It's tried and true. And all it does is say, hey, if you're looking at the record here, you need to be aware of this lawsuit in this docket number. It involves claims that are affecting the title. You better do a little bit of a dive on this to see what was going on. So it's a document to provide notice to the world that something is going on affecting the title. I do in my day job, I do some commercial foreclosure work, same thing. You file your complaint, and then the complaint is followed up with a notice of lis pendens. It's got legal significance in the sense that it cuts off folks that take liens after you. The lis pendens will cut them off so that you're not constantly looking at the title and updating your complaint. If you think about a foreclosure, you've got a bunch of folks maybe with judgments or construction liens and encumbrances against the property. You're everyone that has an interest of record, you have to name in your lawsuit, give them notice, but then the lis pendens is there for two purposes. Gives the folks a heads up that the case is going on. And two, it cuts off other interests. So that it's like, think of it as like a place saver, a bookmark, right, in time, because your county recording records, every single day, they're recording documents at the county. And the document that's filed first has priority over the document that's filed second. So the lis pendens is essentially a placeholder in the record that says, hey, there's a case out here. It involves this property. Now, in this case, it's involving all of our properties. And when a judgment, if and when a judgment is entered, it's going to relate back to the date of the filing of that lis pendens. But for your purposes, folks, it was a mechanism to give the world notice prior to the entry of the judgment. Same type of thing, that there's something going on. You are obligated, Mr. or Mrs. Searcher, to do a deeper dive and figure out what is going on with respect to this property. When they do that, they will learn that it is not a personal judgment against the individual owners. I know that last time a lot of folks were worried about that this judgment would be a personal judgment against him or her. That again is not the case. So anyone doing the deep dive that they would be required to do will soon learn that this is simply about the payment of the recapture fee and that it's not against you folks as quote unquote bad guys or deadbeats or judgment debtors or someone who didn't pay a fine or a contract. It's not that. It's not a personal judgment.
So, so just to follow up on that, the lis pendens itself is not the judgment.
Right.
Okay.
So Ms. Dwyer, you asked a question, how was Sal able to file a judgment without notice? He didn't file a judgment. He filed a lis pendens, which lets the whole world know that judgment proceeding is underway.
Okay.
And then you still have the underlying lien, which is already in your condo documents.
So can I ask this question there?
Let me, before you do, can I just, it's a good question, and maybe there's other people that I can assuage their concerns by telling you one more thing about that. The lis pendens literally means litigation pending, right? It tells the world that litigation is pending. If any of you out there are worried because you feel you want to refinance your home and the litigation and lis pendens could stop you from doing that, we have already had, Heather can confirm this, 2 or 3 people who have come to us with that situation. And as long as the refinance does not violate the principles of affordable housing for a restrictive unit, we have prepared and we give the title company what's called a subordination agreement in those cases so that you can refinance, and then the lis pendens doesn't apply for the purposes of that refinance. So if anybody out there has that question, we've already dealt with that.
Okay, that was going to be my last question. So I wanted to know about refinancing and stuff like that.
See that? I was a mind reader.
Yeah, you're reading my mind, but I'm just concerned about that part. Like if you wanted to refi your house and you have a lis pending on your house, or when you have the final judgment against you. Now, this is just the lis pending. What about the final judgment? What are you going to do then?
Right. So,
well, let's assume that the judgment's entered and you're still in, if you were still in affordable housing, right? And you went to sell your home to an affordable purchase.
No, I'm at fair market.
I know you are, but I'm trying to give you general answers so everybody understands. If you're in a restricted unit and you go to sell and you call CGP&H and the sale is approved and the purchaser is approved, the recapture fee is paid, and we subordinate to that sale, the judgment to that sale for the purposes of letting that sale go through. But the lien then goes back in place so that when you ultimately go to sell it at fair market value, the lien still is protected and the judgment is still protected. So if you want to refinance or you want to sell, you call CGP&H. Heather will probably call me or Mr. Bellardo, and arrangements will be made to make that happen.
Yeah, and anybody going through a refinance should also engage with Mr. DeFazio's office, explain the situation. There's a mechanism, what he's saying, set up that we're not looking to get in the way of you living your lives. You have a refi, you'll be able to complete your refi. That's
Okay.
absolutely the case, provided the terms of your refinance are consistent with the affordable housing program.
Excuse me.
And, there was a mention about that Sal and Heather had already gone through this process. Sal, or maybe Heather, you can answer. How many times have you, since the pending litigation, have you assisted folks in going through that refinancing process?
I believe there's been 2 or 3 just in the few months since we filed the complaint.
And no issues with getting the banks to understand the process?
No, not to my knowledge. Heather?
No, it's been fine.
I understand the mayor's on the phone, but I wanted to ask you a question. I want to say, the mayor, could you understand me as being fair market or these other people that bought at fair market? You want them to contact the attorney or the BHS or whoever's in charge of the association to get a letter to say that they can sell their property, they can get a refinance on their property? What person would you want them to do? I own another house. Why would I want to go through you guys to refi my house? I mean, Mayor, you're sitting there. Would you want to do that? Do you think that?
Actually, you won't do that.
You just said we have to go through
No.
that.
No. What will happen is, let's say you get a buyer for your house at fair market value. That buyer has a title company.
I'm not talking about buying. I'm talking about refi.
Well, you said both, so let's do the buy first. If you have a buyer who's buying your house at fair market value, their title company is going to see the judgment or the lis pendens, depending upon what state we're in at that point, where we are status-wise. And they are then going to contact us to ascertain how they write an exception for that. In other words, an exclusion for that. And we would subordinate as long as the recapture fee is paid. And the same thing is true on your refinance. As long as you are refinancing, if you own a $90,000 unit, you can't go out and take a $300,000 loan. At that point, it's no longer, you're no longer maintaining it as an affordable housing unit. You understand that? As long as it meets the constraints of affordable housing, we will subordinate to the title company for the lender or for you if you're refinancing, so that you can go forward with your refi.
Okay, I understand that. I'm listening to you, but I'm just saying to myself, I own another house. I can't imagine me going to somebody to say, I want to refinance my house, and I want you to give me okay to refi my house when I'm at fair market. I'm not at low income, I'm at fair market. So this is what I'm just saying. Anyway, everybody's on this call. We know what we can do. We have to vote. Goodbye. Have a nice day.
Thank you.
Makes no.
Hello, my name is Deborah Falanga, 15 Hyde Court. I also purchased at market value in 2018, but the seller of my unit, Egnatok Family LLC, is listed as one of the defendants. Why am I also listed? I understand what you're talking about, the land, but they are listed. So if this judgment goes through, it's on them, not me. And will I be released from that judgment?
I can't answer that question because what you're stating is impossible. There's only one record owner of your property. You got served in your name on your property?
First of all, I did not get served because I don't live there. I got this information from a neighbor, but I have not personally been served.
Okay. Well, there are some people that we have not been able to serve because they don't live there, especially in the rental units. And we are trying to locate folks like you and get you served. Egnatuck owned multiple units. I can't tell you why, if he was sued, and to my knowledge, all the units that Egnatuck owned were sold before the litigation was filed. That's why Egnatuck should not be a party to our litigation. Doesn't mean he won't be a party potentially in the future.
As I was looking through the copy that the neighbor gave me, it says right in here on the actual
complaint,
the judgment that you are asking for, that there are two things that need to happen to the owners. And the owners, while the owners remain subject to affordable housing restrictions, which mine does not, and upon the first resale of that condo at market value, my condo has already been sold past the first resale of the market value. So the restriction, it has expired. Is that correct?
No.
Well, then why is it in here like that? It says, and upon the first resale. The first resale has already
Ms.
occurred.
Falanga, let me finish.
Yes.
The obligation to pay a recapture fee expires on the payment of the recapture fee at the point where the house is sold for fair market value for the first time after it leaves restrictions. If that recapture fee is not paid by the owner, that lien continues to attach to the land. If the recapture fee was not paid on your property, it still attaches to your property. That's our position.
I understand that, but what I don't understand is that the seller of my unit is the known seller. I understand if there's not known sellers, the person who did actually benefit from the sale from low income housing to market value, that is the person who should be paying the fee, not me. I didn't benefit in any way, shape, or form.
So Deborah, let me just jump in. You
The
actually have,
Egnatuck family is listed in your list of defendants. It
That-
is in fact
Deborah.
listed.
Deborah,
Yes.
I'm suggesting that you have a unique circumstance here. You should probably speak to a lawyer because the party from whom that sold you that property is within the lawsuit. So there's a mechanism by which you
Egnatuck
can
is not
assert
in
a
the
claim.
He is listed on the defendants, page
That's correct.
2.
He's listed because at the time we filed it, he was still showing up on township records, but proof was submitted that he had sold the units before the complaint was filed. So he's no longer a part of it. But you should
Withdraw what I
still
said.
have, but you should still have your attorney contact me, Ms. Falanga. And I think if you do that, a brief conversation will answer your questions.
Can't believe I have to get an attorney to get my name taken off this. I just can't even believe that that is a thing. I
So
did
would she
nothing
be,
wrong.
would she as well be served by reaching out to her title company, just as you,
Yeah.
you advised earlier?
Anyone on this call that is a purchaser at market rate, where the lien should have been satisfied when you purchased, you should be picking up the phone and calling your attorney, calling your title company and saying, what gives? How is this lien on my property? You insured my first lien on this piece of property. The lien that the township, or excuse me, the BHHC is asserting here is quote unquote superior to my interest. And that's why I have title insurance. Please defend me and insure me. If the title company comes back and says, sorry, it's an exception, sometimes you'll see on a schedule all of your exceptions. And if it says any item that could be found in this DCR, you have to direct your questions to your lawyer.
Mhm.
Why was it missed? Why was this not seen? Why was it not satisfied? If you're, I'm sorry, I don't know if you were a direct purchaser, like the first purchaser at market, or if there were subsequent, you're a second or a third, but.
First,
Okay, you're a first. Okay, so for folks who are second or thirds, maybe the recapture fee was escrowed in a prior transaction. But again, my advice to you would be the same. Call your lawyer, call your title company and explain your situation and demand the ability to ask the title insurer to indemnify you. That's why you have title insurance.
correct. I have one other question, and I'll make it quick. If I purchased my unit at, let's just say 100,000, and I sell my unit in 2 years for 100,000, is that recapture fee going to go to the next seller?
No
If there is
recapture fee.
if there is no profit?
It's the recapture fee is measured on the first sale after the end of restrictions.
But the first sale after the end of restrictions has already happened. That is my point.
I understand that.
So Mr. DeFazio is saying then the amount in controversy concerning your particular unit is fixed at that 20% of the gain, okay, of your seller's gain. So that item of damages, if you will, is fixed. And what Mr. DeFazio was saying earlier is that he's going to try to collect each of those dollar figures for each of the units. And that's going to equal a number. He's going to try to get that money from a collateral source, meaning the former attorneys and malpractice carrier. And if we can get the money from the malpractice carrier, then your problem likely goes away. I
The
think
judgment
I heard
will
Mr.
be-
DeFazio to be saying.
That's correct.
The judgment will be released. Is that correct?
No. Don't.
If that's
don't
the
walk
case-
away- Don't walk away from the conversation misunderstanding. I can't promise anybody anything. However,
Right.
we are pursuing litigation against the prior counsel to the BHHC, who in our opinion was part of the reason that these issues occurred. And if we prevail in that litigation and obtain a judgment, or we settle that litigation with his insurance carrier, then those monies will essentially be paid in lieu of the money that you would owe on your unit. Do you understand?
Yes, basically we're being used as pawns. Awesome.
You know what?
You have no idea how you are affecting our lives, and you are using us basically as pawns, legal pawns. And that is not okay. It
Actually,
really
that's
is not.
That's not the case at all, and I'm not going to argue with you. Can we get the next question, please?
I'm not going to say thank you because I am not thanking anyone on this conversation.
Hello, can you hear me?
Rosario, how are you?
Yes, I'm calling from an owner from Five Height, and I bought also after the restriction period, and I am the first buyer. And I would like to understand a bit more about if I accept this, what am I accepting? The first thing is I am accepting that the amount of the recapture fee, I don't know that amount. That amount is not specified anywhere. So how do I calculate that amount? What I'm understanding from here is that it's not going to be my cost basis versus my gain. It's going to be my seller's cost basis versus her gain.
That's correct.
I have no idea about that information. So I need that information to decide whether I accept or not. That's one thing.
Well, that's information that I can't give you right now because that's all part of a search to try and, you understand there are a number of units in this situation. We have to do the searches to put together what those numbers are. And then we have to also consider other issues that go into the calculation of a recapture fee. So I'm sorry, Mr. Burnham, I can't give you that number right now. You probably can get a reasonable facsimile of what the number is by looking at your title work when you purchased, because that will show you what your seller purchased for and what your seller sold for. So let's say your seller purchased for 90 and sold for 120. There would be a $30,000 difference. That gives you somewhat of an idea of what the 20% would be attributable to, although commissions come off the top and other costs may too. So I can't give you a hard number, but by looking at your title work, you may be able, and if you call your attorney should be able to pull up your title policy if you don't have it, pull up the title binder, look at the history of sales, and tell you what they bought for and what you bought for. That'll give you some idea.
And I think that that's a worst case scenario because it's not taking into account any deducts that your seller would have otherwise been entitled to reduce that obligation. So that by doing what Mr. DeFazio is suggesting, it's going to tell you in round numbers what the maximum recapture fee would be.
But also, once again, come back to Doug's earlier comment. Pull up your HUD form from when you purchased to see if there was an escrow established. And also call your title company and make, just as Doug suggested earlier, make a claim against your title company if they did not pick up the recapture fee obligation when you purchased.
Right.
And call your attorney, Mr. Bruno.
Yeah, I called my attorney and I also, he has spoken with you, and there is an exception in the title company, so the title company is not going to cover. So then we are actually going to claim this to the attorney who was involved, to the attorney and the title agency. So we also need to understand how much we need to claim.
Yeah, so I would venture to guess that everyone on the call here that purchased had title insurance as part of the transaction. You buy title insurance just for these very things, these things that come out of the woodworks, that all of a sudden someone's making a claim that's superior to your ownership rights, right? So you're saying, what the heck? You know, how can that be? That's why you have the title insurance. So call the carrier. If they, what I'm suggesting, step two is if the carrier comes back and says, sorry, it's an exception, we've accepted whatever's in the DCR or what's a public record, then you've got to have a difficult conversation with your lawyer. Because at that point, the lawyer's on notice, right? It's in the exception as something that they're accepting out. We're accepting out anything that's in the DCR. A lawyer would then say, well, what's the DCR? Let's look at that. And that evidently is where there's a breakdown here.
So the question is how to calculate the amount of the recapture fee. And I'm not sure if something that, Sal, between you and Heather, you could assist them on.
Well,
I can tell you the Somerset County land records, you can, it's freely searchable. You may have to apply for like a user ID, but it's all for free. And you have the ability to search the records by municipality, by block and lot. So get to your title policy, your deed, it's going to have a block and a lot in there. You can plug that right into the computer and it will tell you the history of all the transactions on your property. Okay.
and again, that will give you a general idea of what.
Right. And the deed itself, the deed is supposed to list the consideration. So if you paid, I'm just picking numbers, okay? If you picked $150,000, you're going to see on your deed, you know, in consideration of $150,000, seller conveys to you the property. Do that search for what your seller purchased for, and then you have a pretty good idea of what the worst case looks like. So at least when you're discussing with the title company, you have an idea of what the potential exposure looks like.
And when we are claiming back to the title company or to the attorney that was in the transaction, are we claiming them to pay that amount now or whenever we sell the house, we sell the unit?
Yeah. So, you know, I put title companies on notice, you know, my day job, and what you'll basically get back from them is one of two things. You'll get back a letter that says, thank you for your claim. You're not covered for the following reasons. Or you'll get, thank you for your claim. This will confirm that we will indemnify you if and when the time comes. But that's the letter you want to get. The letter from the title company saying, we picked up the claim, we'll indemnify you for that. And in addition to indemnifying, the title company will assign you an attorney to represent your interests in court. And they're giving you comfort that if, you know, we're going to assign a lawyer for you, That lawyer will gladiate for you, but if it turns out that we're wrong and we have to pay this amount, don't worry about it. We'll pay it for you. And again, that's why, folks, you get the title insurance. The devil will be in the detail. I don't want to give anybody any false hopes here. The most important thing to look at in your policy is the exceptions. Make sure there's nothing in there about items of record or the DCR specifically called out, because if it is, then your discussion moves from the title company to your lawyer.
And that's exactly where we are. We know the exception is there, so the title company is not going to cover. So now we need to go for the attorney. So we need to get that letter from the
Mr.
attorney.
Bernabo, have your attorney contact me.
Yes.
Okay?
Yeah.
Thank you.
Thank you.
Thank you.
Hello. Can you hear me?
Yes.
And my name's Rick Bauer. I represent RJB Enterprises. We own 67 units in Parkside and Cortland. And so we've been following this closely. It's still very confusing to me. And you know, I have tried to call Mr. DeFazio, and my attorney has tried 3 times. So far, we haven't gotten a call back.
You're Mr. Bauer, your attorney is on the list for callbacks.
Okay.
You can imagine seeing what you're seeing here. My day, I could take 8 hours a day if I was doing nothing but this.
Oh, I understand that. And now there is an attorney that is trying to put together a group also. He's not my attorney, but Peter Ciparulo, I believe, is trying to represent, and he's very reasonable. He's trying to represent all of the people, because I actually feel worse for the people that purchased at market rate after listening to this discussion than I feel for myself. But in any case, I have a different situation because we've owned the units for about 20 years or so. And
Your units are still in restriction, correct?
No, they're all out of restriction.
And you haven't sold any out of restriction?
They're all rental. We sold one. Sold one to Mr. Egnatuk. But that's why we have 67 now. And what doesn't make any sense to me, I'm not a lawyer, and I understand this thing about obligations with the land, but it still doesn't seem to make sense that everybody's getting sued except for the person who kind of walked away with most of the money.
Well, what I can say to you in that regard, Mr. Bauer, is that from our perspective, in my position representing the BHHC and its successors in trying to reduce to judgment and stop the bleeding with respect to recapture fees that weren't paid, I don't have a direct claim against the sellers because of the in rem nature of the lien. The lien lies with the property. That's why we're approaching it this way. This stops anybody in the future from falling into the position that some of these unfortunate folks are in, where they purchased a property and the seller didn't pay the recapture fee. So we've stopped that bleeding. At the same time, as I've tried to explain, we are going after the causes of why they weren't paid in the first place in the companion litigation. If that's resolved, we believe that we will be able to resolve the outstanding liabilities of those folks who, for whatever reason, their title company didn't pick it up, or there was an exception, or their attorney didn't see it, or for whatever reason, their capture fee was not paid. So, but in your case, you got 67 units. They're all out of restriction now, and we don't have to worry about having 67 people who purchase those and don't get the recapture fee paid because A, you were going to pay it in the first place, and B, if you weren't, the list pendants is going to make sure that you do.
I understand. But I still, I don't quite understand the approach kind of the town is taking. And I do, would you share is that other lawsuit posted anywhere? Can we get a copy of that?
Well, of course, it's a matter of public record.
Oh, okay.
It's a matter of public record, and it's against the prior counsel to the board.
Whose name is, I believe, Schmier.
Edwin Schmierer of Mason Griffith.
And now he wrote a letter apparently to Egnatuck that was so bulletproof that you can't go after Egnatuck. Is that the case? He wrote a letter apparently to the previous sellers that was so bulletproof that you have to go after him rather than.
I'm not aware of any such letter, and quite
why
frankly,
are you going after him rather than the person who didn't?
I explained that. I explained that to you. Okay. He was a seller. The lien is not against him. The lien is against the property.
Gotcha.
Okay.
Okay.
Now let's assume
but
at some
wasn't there
point-
an obligation of the seller to?
Absolutely. All the sellers who sold and didn't pay recapture fees had an obligation.
Right.
And
So I still don't understand why you're not going after them.
Well, let's assume in this litigation, one of those folks goes to their attorney and I explain to them what the situation is, and they decide that they want to do that. I don't think it's economically appropriate because of what I've explained to you about how I think this ultimately resolves itself. I don't think it's necessary. But if they wanted to do that, they could go to their attorney and go after their seller. They could.
It seems like you're putting a lot on individual
I'm not putting anything on anybody. I can't go after them. I don't have standing against them.
Okay. No. All right. Well, you do have standing against previous owners of the unit, I would imagine.
No, I just explained to you, I don't.
Okay. You no longer have that.
No longer?
Well, you did when they owned the units.
Of course. Yeah, we would have standing then.
Was
yes.
A couple years ago, and there were meetings about this a few years ago.
Well,
I remember.
There were meetings dating back to 2017. Unfortunately, I only became involved in, I think, May or June of 2020 when this process that we're dealing with right now started.
Okay. The other thing, when you were kind of spitballing the numbers as far as what these recapture fees would amount to, as far as anything that Egnatuck sold, it would be at least would have at least doubled his money on the unit. So it would be a lot, probably more than what we were talking.
Oh, I don't know. I was using numbers to make it easing. If I used 190 and 90, so
I just didn't want anybody to be just misinformed at all. Okay, I hope please get back to my attorney on this.
Attorney's name, I'll see if I can call him tomorrow.
His name is Stephen First.
I know Steve very well, and he has called me. He is on my list. I'll call him tomorrow.
He mentioned that he had met with you before.
Yeah, we know each other.
All righty. I think that's all I have. Thank you.
Thank you, Mr. Bauer.
Thank you, Mr. Bauer.
Hello.
Yes.
Yes, hi. My name is Lily and I live in 107 Cortland Lane. I have a few questions, sir. During the
Hello,
30
Lily.
year, hello, sir. During the 30 years, I'm sorry, give me 1 second. I'm just gonna make sure that. During the 30 years of the Mount Laurel Law and the units that were considered low and moderate income houses, some of these units were sold during that time, and the initial sale of the unit, that lien was removed. But it seems to me from the research that I've done, I noticed that there was no lien placed in place of the previous lien. Wouldn't this be considered a breach of contract on the behalf of BHAC and the township itself?
To my knowledge, you're incorrect, because the master deed is something that every purchaser of an affordable unit has to ascribe to. And the master deed contained the covenants and conditions that we're talking about. So I don't know
Yes,
where
but
you,
wasn't it Sharon DeSico, not Sharon DeSico, sorry, but wasn't it?
Lillian, let me finish. Let me
BHAC?
finish, please.
Okay.
Let me finish. So I don't know where you get the notion that the lien was dismissed, because it runs with the land. So it was never dismissed.
I'm not saying that it was dismissed. From my understanding, and I'm not an attorney, I'm definitely gonna tell you I'm not. But my understanding is that if the property is sold, then, and it's sold to a new potential purchaser, that there should be a lien on the property stating so that it's still under the Mount Laurel law, that they still have to pay the recapture fee during that time.
You're talking about a sale during the 30-year restricted period.
Yes, sir.
Any one of those sales would have to have been approved by the BHHC before, now by CGP&H, right? Because
Yes,
you would have to have the buyer qualify as an affordable housing purchaser.
Okay.
And the recapture fee would be paid as part of the process of CGB&H being involved now, or BHHC before, and the lien would remain in place because the master deed doesn't go away.
Okay, thank you. Now, the other question that I have is, you're telling everyone to contact their attorneys to get, and if they're trying to refinance or purchase or sell their house for a subordinate document?
No, I didn't say that at all.
Okay,
What I
so-
said is, if you go to refinance your home,
Mhm.
are you still in a restricted unit?
No.
Okay. Well, if you go to refinance your home, whether you're in a restricted unit or not, you're not going to be able to refinance as long as the lis pendens and the complaint are pending against the property.
Okay.
But if you go to refinance, your title company that's writing the title as part of the refi can come to us and ask us for a subordination agreement for the sole purpose of the refinance. You don't have to get, you understand?
Yes, I understand.
Okay.
Sal, you're Sal, right?
Yes, I
Just to
am.
make sure. Okay. Now, the other question I have is, sorry. So with the lien not being satisfied after the first seller of the property, when it's no longer under the Mount Laurel law, I know what you're talking about, how the BHAC didn't collect a recapture fee on those units in Parkside. And then you've placed the lien on the properties. My question to you is, if was there first place on the new owners? Okay. If you're telling everyone that they need to get an attorney, the people who didn't have to pay the 20% initially, because it was supposed to be, I don't know, he was saying, Mr. Bauer was saying Edna Talks company was supposed to pay for this. Now you're telling everyone.
Stop.
Mhm.
Just want to keep you on track, okay?
Okay.
I understand your question so far. It's not just Mr. Egnatuk as a
No,
seller. There
yeah,
were
there's
other
a few.
sellers also, right?
Okay, so even including the other sellers.
Right.
Now you're telling everyone that they have to get an attorney. Who's going to pay for that attorney fee?
I never said to anyone that they have to get an
That they,
attorney.
no, you're telling them that they have to go and speak to their attorney, and
No, I'm
attorneys
telling
cost
people,
money.
Ms. Gonzalez, I'm telling people like I'm telling you, that if you have, we are holding these sessions to try and give as much information about what's happening as we can, with the constraint that I cannot provide legal advice to any of you. Do you understand that?
Yeah, I understand that.
So if you have legal questions, or if you have questions that we're not answering, if there's open questions here that we're not answering, The only thing you can do is go to someone on your own behalf and have them call me to discuss it. I've been fielding calls from attorneys since the complaint was filed. And I'll be happy to do that. And the BHHC is paying me for my time to do that. But they're not going to pay for your time to hire an attorney. So if you decide to do that, if you bought a unit, did you buy an after restriction unit, a unit at fair market value?
Yes.
Did you have an attorney?
We don't have to talk about that. I have other questions, actually.
No. Stop. You're suggesting that we're telling you to hire an attorney. What I'm saying
No,
is,
I'm not suggesting. You had said to, before the other people that were talking, you were saying, you need to speak to your attorney. You're not suggesting, you're just saying, just speak to your attorney. So my thing is that if this wasn't such a mess in regards to everything, Sal, let's be serious. You're an attorney, so you're getting paid. And all that money that you're getting paid through the BHAC should be going back to the community. We're low, moderate income housing, and you being an attorney, you're getting a huge cut of this money, and that's not fair. So you guys need to be more organized.
you're not part of the affordable housing anymore, right? Your house is fair market value. And number one. And number two, where I differ with you.
But that doesn't mean anything, even if it's fair market value.
As I explained to someone before, the purpose of this litigation is to go collect monies that are due in 7-figure amounts, which all will go back to the benefit of affordable housing. So
I
when
understand, but you having everybody's attorney calling you, that means that you're going to be racking up most of the money from the BHAC.
Well, you know what? I'm here to address questions. No, that's not true.
We can stop. We can have
I'm
this.
here to answer questions about the litigation. I'm not here to answer questions based on supposition. I apologize, Ms. Gonzalez, but I can't answer your accusatory questions, okay?
Okay,
Mr. Gonzalez, let me just jump in. Mr. DeFazio has offered to interject into a particular situation if a homeowner is in the process of trying to sell or is in the process of trying to refinance. He's offering to assist in that process. He's not stating that everybody has to get an attorney. We talked about the stipulation that we put in place here to avoid that very thing of having to have folks arbitrarily go out and spend money. We get it. We understand that this is an imposition. But if you have a property interest in your particular unit that you feel that you need to protect because you don't feel that for whatever reason this recapture fee should apply to you, then you owe it to yourself to protect your asset and to retain an attorney, or at least to talk to an attorney to see whether your concerns are valid or not. Then maybe they are. You may have a unit, you could have had the recapture fee paid or escrowed, or what for whatever reason you feel as if this shouldn't apply to you. You should speak to an attorney because your house is your most significant asset. I get it.
Or in the position that you have a house that aged out of restrictions.
Yes.
So don't hear Mr. DeFazio to say, everybody needs to hire an attorney and then they should all pick up the phone and call me. I would venture to say, the phone calls are, it's time and attention away from moving his case forward. So this is something he's offering to do sort of as a courtesy here to facilitate folks that
As a courtesy,
are
but you're
being-
getting paid.
are to assist folks who are trying to go through their lives, live their lives, don't want to be bothered with the lawsuit, understand that the recapture fee applies, but they're caught up in this net. The net is necessary because people are closing and not paying the recapture fee. If that continues, there is no affordable housing fund. So this is, taking a step back. All of this action is designed to preserve and protect the very program that's given all these thousands of folks an opportunity for a good start. And we want to make sure that it's there for the future.
And the stipulations are already there. The stipulations that Mr. DeFazio described earlier on the website. If you have an option that you want to know what's going on in the litigation, the stipulation says, I don't want a default judgment against me. So I understand that this action is formalizing a judgment that is already reflected in the DCR, in the condo documents. And by following that stipulation, all it is letting you know what is going on with the legal process as it makes its way through the court. Doesn't require a lawyer to get involved in that. And Mr. DeFazio put that on. Really, it was a suggestion, an idea that came out on the previous conference call we had.
Okay. Now I have, the other question I have is that all these units that I guess his name was Mr. Rick Bauer, he said he has rental units. They used to be under the restrictive guidelines. And now that they're no longer under the restricted guidelines, what is going to happen? Are we going to have more buildings being built in Bedminster in order to have more affordable housing?
Okay, I'm sorry, Ms. Gonzalez, can you repeat that question?
Okay, from my understanding, Mr. Rick Bauer had a lot of the rental units that were considered moderate and low income, but now they have phased out. So I know that we're supposed to be able, according to the state, that we're supposed to have X amount of properties that are considered low and moderate income in the Bedminster Township area. Have we fulfilled that? And if we haven't, then are you planning to build more units?
Oh, we're not planning to build units, but under the agreement that Bedminster negotiated with Fair Share Housing Center, which is the state's housing, affordable housing expert, which is sort of handling the litigation.
Yes.
The state, Bedminster had an obligation under a settlement that was reached probably about, I was going to say about 4 years ago, that by June 30th or July 1st of 2021, we had to have had either built by developers or zoned for 28 affordable family rental units.
Okay.
We don't need, at this point, we don't need any more for sale affordable units, but we did have an obligation under that
The rental
with Fair
units,
Share
right?
Housing to come up with 28 rentals.
Have
And
you
those
fulfilled that
28
now?
those 28 are being addressed by one project that is going up on Lamington, up by 206, and a zoning that was just put in place on the corner of 206 and Burnt Mills Road.
So do you
That zoning
agree?
is in place that now satisfies our obligation under the third round COA rules, but the fourth round of COA rules will come out in 2025.
So my question is, do you agree to overdeveloping Bedminster?
No, not at all, which is why we have to make sure that we keep units in restriction and that we redeploy the very monies that we're talking about to preserve the affordable housing, both the for sale affordables and, to the extent there are any out there, the rental affordables.
So were you?
And that will stop, Ms. Gonzalez. That would actually, having that money would put us in position to not overdevelop Bedminster. And just where you live right now, and where a lot of us live or have lived, is in the hills. And the hills is a function of Mount Laurel litigation from the 70s and early 80s.
So moving forward with this, are you willing, because my thing is that instead of having developed these new units, was there any way that you could have bought them from Mr. Edna Tuck if he had the rental units? Or else asked him if he could have put it back into the Mount Laurel for another 30 years, rather than developing more here in Bedminster?
I don't know about that. I know there may have been, let's see, those rentals, I'm not even sure if they were counted, but I have to go back to the litigation that was addressed before I was mayor. So Ms. Gonzalez, that's what we intend on doing, frankly, with a large part of this money. And one of the jobs that we've actually tasked CGP&H to do is to look at using these funds for that very purpose, so that we don't end up in 2025 with another Hills development project or something of that magnitude.
Yes. So when you're saying this, the recapture money, that this is what you're talking about, the recapture money, basically using that money to build the new units and also making sure that it stays within the Mount Laurel law. And we continue doing this. So my question too is that isn't part of the recapture money also to maintain current existing property viable? It's not just the associations that are supposed to do this, but from my understanding, I thought also some of the money goes to this.
Well, that
Because in
understanding,
Portland,
Ms.
because
Gonzalez,
Portland, we
your
haven't
understanding, there's a affordable housing spending plan. And I do know that you are aware of that. And that the funds in the affordable housing spending plan are supposed to go to qualified residents. In other words, those who are qualified under the affordable restrictions.
No, I
Heather Mahawi-
understand.
Heather can go into a little more detail about that. And this was actually discussed at the Affordable Housing Advisory Committee last week. And one of the things that Heather is looking into is deploying some of those funds to unit owners. And also, is there any opportunity within the spending plan to deploy those funds to associations? But at the same time, you do have to realize that the spending plan is not a stand-in for condo associations. The condo associations still have an obligation to run their association.
Yes.
Collect dues. They're supposed to, not dues, well, it is dues.
Monthly
Yeah.
dues.
Yeah, they're supposed to,
Yeah.
and they're supposed to redeploy and keep their associations in good shape. If you have an issue with your association, you should take it up with your association management and your association board.
Okay. Thank you. And then the other questions I have are for Heather. Heather, my question to you is that who inspects the houses before they're being placed in the market? And also,
Ms. Gonzalez, I
Wait.
think that same question has been asked 3 times now. And if you have a specific question about selling your unit, please
No, I have
reach out to
a-
CGP&H directly.
Okay, so no, the only thing that I do have is because I have a neighbor that moved out of my complex. I have their house keys. I was told by them that the new company told them that they needed to give their house keys to a neighbor so that they can show their property. I'm not a real estate agent. I've never sold a property. I've never shown a property in my life. And I just think it's very, very odd that since they left, I've opened up the door, brought people in, and the individuals that left the house, they've been calling me, and it seems that everyone that's being sent to their house to be, looked at, they're not certified or qualified and to be prospective buyers. So why, before they even come to see the house when I open up the door? So I don't understand why this is happening.
Ms.
I would assume
Gonzalez,
that they would have
Ms.
someone that's
Ms.
certified and
Gonzalez,
qualified.
Ms. Gonzalez, I would say to you, a little unsolicited advice to you, don't do that. Don't open someone else's door to show them their property. That's on your neighbor to sell and to market his or her property. You're only going to get yourself into trouble by doing that. And I don't mean trouble like law, but if someone were to go in there and slip and fall or something is stolen, they're going to look to you for providing access to the property. So that's a very bizarre set of circumstances you're describing.
for
It's
letting
something
me
I
know.
would
I
tell
had
you
no
that you should
idea.
not continue to do for your
No,
own
thank you for
well-being.
letting me know, because I had no idea. I just thought it was very strange, and
It
they've
is
been
odd.
having a difficult time selling their property. And when they call me, they said their perspective supposed to be the people that are coming here to see their property. They're not even certified or qualified as
Yeah,
of
I mean-
yet before they even come in. And then I said to them, okay, I'm not feeling comfortable showing this property. I'm not a real estate agent. So if they're no longer in their house, who's supposed to be showing their property?
Well, Mayor, we have a lot of people on the line waiting to talk about the litigation, and I think you've said it before. I believe these are questions that can be posed to Heather with respect to a specific sale, but they're not about the litigation.
Okay.
Thank you,
Thank you for your time.
Thank you, Ms. Gonzalez, and you do have Heather's email, so you can please reach out to her.
Yes, I will. Thank you.
You.
Good evening. My name is Jeanette Carlucci, and I live at 49 Cheswich Court. And I had a question about how the recapture fee is calculated. If I bought my unit 16 years ago for $100,000, I was told that there was an incremental appreciation. And so say it was $1,000. So if I sold my unit now under BHHC, if it was like 1% per year, it would be $116,000. However, the Christie administration froze the incremental appreciation. So there's no unit in BHHC's inventory that has gained a nickel of appreciation in the last 6 years. And that was part of my decision to go fair market. My question is, why would I be paying the recapture fee on what I get and not on what BHHC would have given me? That's number one. And number two, why were we not notified that the Christie administration had frozen the incremental appreciation? I found it out only by a fluke because I went in to talk to Sharon DeSico.
Gentlemen, this is not a question about the litigation, so I can't answer it.
It is too. Yes, because it's the quantity of recapture.
No, well, to the extent you're asking me how to calculate your respective recapture fee, my response would be to get in touch with CGP&H, and they can give you the criteria that are used for assessing what the recapture fee would be on a given transaction.
In a nutshell, without knowing the specifics of your transaction, it's 20% of the gain. So you recover all of your purchase price, and then whatever's left of the gain is 20% of that. But there's also an element in there about improvements, and that's why we suggest that you reach out to CGP&H, because
Well,
we want to speak about what your improvements are.
I'm curious as to why anybody would have kept their unit under restriction had they known that they're not getting a nickel of appreciation anymore. Where they're paying $275 a month for the upkeep of Bedminster Township's affordable housing inventory, and they're not getting a nickel for it.
I will say this is Mayor. Ms. Carlucci, I don't understand your question. And if you have a question regarding the calculation of the recapture fee, that goes to CGP&H. If you have a question about what the Christie administration was doing or not doing, CGP&H may be able and best to address that question as well.
But the question is,
for them that worked with COA and worked with HMFA, so they certainly have knowledge about how the resale prices were calculated. But the rest of your question, I don't necessarily understand. Is your question, why should people pay any recapture fee? Is that the issue?
no, the point is that the recapture or the incremental appreciation has been frozen. So in the last 6 years, there has been no appreciation for any recapture fee to be extracted from. Does that not make sense to you? What I just said?
It's not making sense to me only in the sense that when you're if you go to market, it's dictated by not an appreciation based on a year, but it's dictated by what they're willing to pay you in the market.
Oh,
You
she's
can put
talking
your
about-
unit on the market for $500,000 and nobody, you don't get a sniff. You put it on for $50,000 and it'll goes tomorrow. So it's a market-driven sale.
Is
What are you
your
talking-
unit, your unit is still in
Are you talking
restriction or
about-
your unit is market?
My unit is now market. And the reason it's market is because I found out by a fluke that it was not gaining a nickel of appreciation.
No, the reason it is market is because the restrictions lapsed.
And I allowed it.
I understand that, but,
Yes.
but.
I did not re-up. I did not
But
re-up.
the value of your property is not dictated by a regular incremental increase based on value. It's dictated by what the market is willing to pay you for your property.
I know, but I'm talking about the people who are still under restriction. See, the township of Bedminster for the last 6 years has not gained a dime or a nickel of recapturable.
So I understand. So you're saying the premise based of your question is you're saying that there's been no recapture fee obligations over the last 6 years because no one in restriction has made a profit on the sale of their property? I don't know whether that's true.
No, they may have if they bought it 20 years ago, but if they bought it 6 years ago, there isn't any.
Can we unmute Heather for a moment? I think she's got her hand up. Maybe she can fill us in on what this is about. Heather?
Hi, yes. So you're correct that while there was a lot of flux with COA and they were shutting down COA and all that, it was zero for a few years. That's right. But it's gone up. There are, in the past 4 years, there have been increases. And in 2019, I think there was an attempt to get back some of the increase in 2019 was 9.64%, which is almost 10%, which is quite an increase on a house value. So they have tried, there have been increases. People are seeing increases in their prices. It was 0% for a few years, like I said, while they were figuring out if COA wasn't going to do this, who was, but have since made the reparations for that, come back and given people those increases again. So people are getting increases on their affordable house values.
And Ms. Carlucci, I have a question for you.
Yes.
What would you be interested in putting your unit back into restrictions?
Well, I didn't have a problem with paying the 20% on what I would have gotten from, under restrictions. But once Sharon DeSico told me that my unit was no longer increasing I had no longer any appreciation, I said, wow, that's not fair. And not only that, we were never notified. Who was going to tell us that, right when this whole thing was happening, when we were making these decisions about whether we were going to stay in restricted or whether we were going to go fair market? I mean, this was a deciding factor for me.
Well, Ms. Carlucci, I can't go back and fix what Sharon did or didn't do, or what Schmier should have done or didn't do. But I am curious about if there is an inducement that would put you in the position of putting a restriction and starting a 30-year clock from today moving forward. That would keep you in your unit. Your unit would go back into the affordable inventory. In other words, it could only be sold to qualifying low income or moderate income residents, depending upon where it was placed, and would put you back into the affordable taxation rate. Now, is that enough to overcome the monies that you would get at market maybe, maybe not, but that really depends on your situation.
Yeah, but are you
I
going
am
to,
curious about if there is something, because once again, as I mentioned earlier, this was to Ms. Gonzalez's comment about keeping units in the affordable program so we don't get stuck with another large development project. So if that's something that you're interested in, or if there's a threshold point that would induce you to put the restriction in, whether it's a $5,000 payment, a $10,000 payment, that's actually something that Heather Mahali is looking into right now. So that's why I'm asking that question. If that is something that's of interest to you and maybe of interest to others who are long-term residents and they're going to stay in their unit no matter what for the next 15, 20 years, the allure of going to market may be offset by getting money now and maintaining your low taxes as opposed to going to market taxes. So if that's something that is of interest to you, I would once again ask you to reach out to Heather Mahali and describe and discuss your situation.
Mayor, you're talking to the group, you.
oh,
I'm talking to Ms. Carlucci because she actually said she was in a point of making a decision of keeping her unit in restriction or allowing it to go to market. And she allowed it to go to market because of some information that Sharon had discussed with her.
Gotcha.
but let me ask you a question. What assurance would I have that the accumulated appreciation wouldn't be frozen again?
What assurance does anybody in the open market have that there's going to be appreciation?
That's not relevant.
In 2008,
I'm sorry,
in
Sal, but
2000
that's not relevant.
Yes, it is.
No, it's not.
In 2008, there were any number of people that were complaining because their homes had lost 20% of their value with the crash.
Okay.
So, but that's a decision that
you
you
know
have
what?
to make.
No.
I don't think we can give any assurances because that's dictated by Trenton. So, I mean, a local municipal unit or an affordable housing program manager can't give any assurances on that. What you would have is the insurance that you would have a lower tax rate for the life of you living there in the home. And what the mayor is suggesting is some sort of preloaded, front-loaded lump sum payment to you to put your unit back into the restriction. And that's one of the things that we're contemplating a program rolling that out.
I would consider it.
Okay, well, so what, Ms. Carlucci, I would ask you to call Heather. And once again, just run through your situation, run through the numbers. And, this will give Heather some basis of making a recommendation that would apply to you and really to roll out across the entire affordable communities.
And you know what? I'll tell you one more reason why I would consider it. Because I was a widow left with 2 children, and I raised them here in an affordable place, and I would want that same opportunity for somebody else. So that would also be a consideration.
Ms. Carlucci, that's a wonderful sentiment, and thank you for those comments.
Absolutely.
That's all I have.
And by the way, that's exactly why we, and saying it's just not Larry Jacobs as mayor, but the township committee going to Heather Mahali, say, Heather, what can we do with the recapture fees that are collected, right? That $800 or $1 million, whatever we're sitting in those accounts, and whatever comes in from the future, and redeploy those funds. And if we can do so by maintaining the affordable housing inventory and keeping those units in restriction, then in my mind, that's one of the best purposes that we can redeploy. And just as Sal said in the beginning, the money is for furthering the affordable housing opportunities. It's not just for the folks who are in it now or have gone through the program and their units are now market, but it's for the next several families that come through. So Ms. Carlucci, thank you. And I do ask you to reach out to Heather so that maybe we can, figure what's going to work for you, and maybe that's something that'll work for others.
Well, I'm here in Jersey, so I'll say, make me an offer I can't refuse.
Okay, Heather, if you, maybe we got to figure out a way to get you guys in contact so you can start those discussions.
Absolutely. My email address and my contact information, I believe, is on the township website under Affordable Housing Administration.
There we go.
Hi, can you hear me?
Yes.
Yes.
Okay.
I'm Ellen Stark. I'm calling on behalf of my brother, Alan Borman, who has a condo in Village Green. We have a lot of questions.
Okay, so we have some questions about my question's mainly about restrictive periods. And so my brother-in-law, he bought a unit in Village Green in 2010, November 2010. And
Actually, it's
was
2011.
2010, and it was subject to affordability controls for a period of 40 years, which brings it out to 2025. But then I was going through some of his paperwork, and I see that he signed a piece of paper with his contract where it said that pursuant to NJAC 597-614, the affordability controls on this property are hereby extended for a term of an additional 30 years from the date of the original expiration, which would have been 2025. And then I looked up the statute, and it says that type of extension only applies to units where the affordability controls are expiring between 1999 and 2018, which I guess would apply to the Parkside section. So my question is, he's never given a chance to make a decision about whether to keep the restriction, to renew it, or to go to open market based on that contract that he signed. So can you explain that a little bit to me about what's going on there?
Who are you posing the question to? Because
I guess whoever can answer it, basically. Which one
I
of you
don't
would be better qualified to answer it?
I don't know what happened in 2018. That's not part of this litigation.
No. I'm not. The only reason I mentioned 2018, I'm saying that when my brother-in-law signed the contract to purchase a unit at Village Green, where the affordability control is supposed to end in 2025, they gave him a piece of paper to sign saying that he was hereby extended for an additional term of 30 years, according to a statute. But the statute, when I read the statute, I saw that it only applies to units where the affordability controls are ending between 1999 and 2018. So therefore, it would seem to me that this was incorrect.
So your question, I totally get it. I hear you. Your question poses a legal question.
Right.
So we would defer to our township attorney. So let us ask the question and we'll try to get that answer for you. I understand.
And Mr. Vorman, if you could actually send a copy of that to Heather Mahali.
Okay, give us the
Where's the?
address.
Sure. You ready?
Wait, hold on a second. How do you spell that last name, Mahali?
It's Mahaley.
Okay, and what's the address we'd be sending it to?
It's HMAHALEY at CGPH.net.
.net. Let me read that back then. So it's the number 8, Mahali.
No, sorry, H. H is in Heather.
Oh, H, sorry. It's H Mahali at cgch.net. And just basically,
It's, sorry, it's CG, Charlie, George, Paul, Harry.
CGPH.
Yes.
So C is in car, G is in George, B is in Paul, H is in Harry.
Yep.
Okay, and just basically everything that I said here, just send it to you.
Yes, I will.
Right.
What's your address?
Well, he's at Alan Borman. We're calling on his behalf.
Okay.
Because he doesn't have a computer or anything. his address is 70 Mountain Court. So that's 70 Mountain Court in Village Green.
Okay. All right, I'll look for those papers and see if I can consult with Mr. Velardo and we can figure it out.
Consult with who?
The township attorney.
Okay,
So once again, and if you miss Heather's email address, it is on the town website under affordable
okay.
housing.
I have it. I have her email. What, Heather, what is your position there?
We're the affordable housing administrator.
Okay,
Okay, I have a stupid question. My husband told me a long time, but I am assuming that all the recapture fees were paid when my brother took ownership.
yeah, we got a piece of paper, the seller, you know, one of the papers we got in the contract showed the amount of the recapture fee.
Your unit, your brother bought while it was still in restrictions.
And it's still in restriction. It's supposed
Right.
to be. in-
So my point is, your recapture fee would have been paid because that would have been a controlled closing, controlled
Right,
by
that's-
the agent.
Good, yeah, that's what I assumed. I mean, my wife was concerned about it, but I was pretty confident that it was paid.
No.
So here, if I could just come in here at this point. So the recapture fee is paid during every transaction during the restricted period.
Right,
So every transaction, whether it transacts one time during the 30 years or transacts 15 times during the 30 years.
okay,
Each transaction has a recapture fee associated with it.
right,
There's one final recapture fee that is supposed to be paid at the first market sale.
right.
And if it's not paid at the first market sale, well, that obligation continues to run with the property.
Right,
So yes, there may have been a recapture fee paid when your brother-in-law bought the property, but there will be a subsequent recapture fee
I see.
when your brother-in-law sells it.
that's
Okay.
right. We understand that.
Okay.
Thank you for, anyway, thank you for clarifying that.
Okay.
Absolutely.
All right, so, okay, then you've answered our question.
Thank
Thank
you.
you.
Thank you very much.
You're welcome.
Okay.
And it is 9:13. Let's, hard stop at 10.
Yeah, I don't know how many more we got. 3?
There are 2 more questions.
2 more questions? All right, 2 more questions. 2 more? That was more than that.
This one's on you, but I'm not gonna- Just have a telephone number that's on you. We've already asked them.
So there's a telephone number,
295?
telephone number that begins 295. If you could take yourself off mute.
Hello.
Hello?
Yes, you are on.
Hi, my name is Elizabeth Furlong. I have been living at Parkside since November 2006, and I'm well aware of the recapture fee. It's in deed, it's in everything, and I don't understand why that my name was put on there against the suit, whatever it is, and you've already put the claim on the condo. I have no plans to sell at all. So what am I supposed to do? I have called the office and your office, and I asked repeatedly, what do I have to do before? Because I don't want to get any fees or in the letter that you have
Okay,
that
are
said
you-
that
are you
there's
s-
going to be some, you're going to have
Elizabeth?
to pay for, yes.
I'm sorry to interrupt you. You sound like the perfect candidate for the stipulation that we put together. So
Exactly.
if you go to our website, it's bedminster.us, and then you navigate to affordable housing, there's a stipulation in there. And essentially what the stipulation says and memorializes is that you were served with the summons and the complaint. You understand that there's a recapture fee. You agree with the recapture fee. You don't wish to be bothered further with the lawsuit, except for the fact you request a copy of whatever the judge's decision is. If all of that applies to you, if you sign the stipulation and get it back to Mr. DeFazio, you're done. You're
I don't have,
validly
I
in the
don't have a computer. The only thing I can do is
Okay.
write a letter. I
We
don't have a computer.
We've got copies here at Town Hall. If you can come down to Town Hall and speak to Robin Ray, our administrator, she'll be able to provide you with a copy of the STIP. And you can just fill it
And
out.
can I
and
sign
write
it
back to
there?
Mrs. Ray. And we will
Is that
take,
at 1 Miller Lane?
yes,
Can I
Yes,
go
and
in
you would
there
not
and just sign my name and then I'm done? Because this is ridiculous.
yes, that's all, that was designed for folks in your situation where you've been bothered with this, you don't have a dispute, you understand it, you know, you don't want to be bothered, and you want to just make sure that you receive notice of what the decision ultimately is. You can sign that stipulation. If you give it back to Mrs. Ray, she'll get it to Mr. DeFazio. And that way, what you're doing at that point is avoiding what's called a default judgment against you. It's going to give you notice of the proceedings, but you're not going to be required to do anything. And you're just sort of rolling along with it and whatever.
What is the name of the person? Robin, you said?
Robin, so it's Robin Ray.
Okay,
Robin
I'll
Ray.
just walk in there and ask for her.
Yes, and there's other folks who are at the front desk who also are well aware of the stipulation. And a number of people who didn't have computers, because a lot of people did do it by computer. They downloaded it and then emailed it to Mr. DeFazio, but there were several, maybe certainly over a dozen, who came into Town Hall because they didn't have access to a printer. And there were copies of the stipulation at Town Hall, ready for folks to sign. And the folks in Town Hall will also take care of getting it delivered to Mr. DeFazio.
Okay, I appreciate that. And also, since I bought in 2006, and I also dealt with Sharon, I know, I'm positive that recapture fee was paid, because I've gone over the papers.
Well, yeah, in 2006, you would have still been in a restrictive unit.
I was, yeah.
Right, and as
yeah.
the mayor
Now I'm not,
claimed-
but before, in 2006, I definitely was, yeah.
No, we understand. I'm just saying that in 2006, when you purchased, it was a restricted unit, so that would have been handled by Sharon and the BHHC. It's the next
Yes,
sale.
she dealt with she did the,
Right.
So there's a difference
me to get
between trying in our minds, in our collective minds, to draw a line between sales occurring during the restricted period and sales occurring at market. If it's during the restricted period, it's going through BHHC. They are aware of it. They know the recapture fees out there. It's what Mr. DeFazio has been describing as a controlled closing. Once the unit transacts and falls out of restriction, so now it's at market, you're no longer picking the phone up and calling BHHC and saying, I'd like to sell my home. You're doing it at market. And then that's where the problem developed, where folks were not searching the records or not paying the recapture fee, and this money was being lost. So what Mr. DeFazio's suit is really to address the folks that are selling their units at market and the fees are not being paid. Unfortunately, everybody has to get.
I understand that, but it was upsetting that when a person knows
Yes.
that, you know, that you have to pay it, and then you still have a lien put on your property.
Right.
Very, very upsetting. You know,
So let me just, if I could offer, let me just offer this, Sal. What folks, you need to, you don't know this, but let me tell you this. The process that Mr. DeFazio is proceeding along was directed by Judge Miller in Somerville. BHHC went and tried to do a test case against one person, okay? And the judge said, no, that doesn't work. The only way for you to effectively do what you're looking to do here is to sue everybody. So against Mr. DeFazio's wishes, I'm sure, because it's been a pain in the neck to coordinate this service here, everybody having to get joined and named in this lawsuit was because the judge ordered that. So unfortunately, you know, the hands were tied here. BHHC had to do what the judge ordered.
Well, I'm sorry, Doug. I just want to correct that for a moment, just so that you understand. I'm sorry, your name again, ma'am?
Elizabeth Furlong. I live in Parkside.
Hi, Elizabeth. What Judge Miller did was he rejected an effort by prior counsel to go after one seller and said that all of the people who would be affected by the lien would have to have their rights adjudicated. That's what he said. It's a little twist on what Doug was telling you, but it's important that you be aware of it. He didn't direct us to file this lawsuit. The fact of the matter is that the BHHC had directed its prior counsel to take these steps back in 2019, and it wasn't done. And we know that you're uncomfortable. We know that people are uncomfortable. And we're sorry that that discomfort had to be created. But the overreaching and most important issue here, I think you'll agree, is that other people will be afforded the opportunity to live in affordable housing going forward. And that's why we have to protect the program. So some people are being made uncomfortable. We apologize. We've created things like the stipulation for you to sign that you'll go down to town hall and sign. We've made it clear we're not seeking any money from any of the residents in another form of stipulation that I filed. So I'm sorry for the discomfort, I truly am. But in the long run, what's more important is that the program gets protected.
Well, the program was protected long ago because no one can even buy this place unless there were mistakes made, because it stipulates right there that you have to pay a recapture fee in black and white.
But people weren't paying it.
Well, that's the fault of the people that were involved in that. You know, that's why all these other people are getting bounced around.
The unfortunate reality is that people like you have been made uncomfortable. People who recognize their obligation have had to deal with this surprise at the end of last year, beginning of this, and because other people let me just finish. Because other people didn't pay what they were supposed to, and I'm sorry you had to go through this. We're trying to make it as comfortable for everybody as we can. It's kind of difficult with 600 plus units, but that's why we're holding these informational discussions to try and answer your questions.
Well, I will go tomorrow and sign my name on the dotted line because I want this to be over with.
Okay.
Thank you for your time. Bye.
Thank you, Ms. Furlong.
iPhone Denise, if you could unmute.
Showing up with a piece of paper.
Oh.
Well, can you change the view? Oh, can you just click on it? Pin it.
Hello?
Hello?
That's someone else. No, that's not a piece of paper. iPhone Denise, did you want to make a comment?
She's back on mute.
Okay, you're off mute.
Hello?
Yes, iPhone Denise.
I'm Denise,
Okay, Denise, we need your full name and address.
33 Larkspur Court,
And Denise, your last name?
Phillips.
How can I help you, Denise?
I like to ask you a question. How about the people that own their property?
I'm not sure I understand what you mean by that.
Well, how about if people that own their property and it's, destroyed? What does that mean? What do you do? with no liens and you own your property. And all, does everyone need a homeowner's insurance?
I'm sorry, Denise, I don't understand your question.
I just want to know, if you own your property, what is your liability towards your
So,
investment?
so in Village Green, so Village Green has not come up on the expiration of its affordable restriction period yet, right? So that's not until 2025 at the earliest. And Denise, how long have you been in?
4 years. 4 years.
4 years? Then your unit might actually be subject to an extension, which is similar to what was discussed earlier by the brother-in-law of Vorman about that extension on the restriction period. But if you own it, if you own your unit, there's a recapture fee when you go to sell. Not until then. You don't owe any money, and you don't owe any money until you go to sell your unit, and that's when your recapture fee obligation kicks in.
Yeah, but recapture fee means what?
When you go to,
It means a percentage of the profit that you make when you sell your unit will be paid back to Affordable Housing Trust Fund for the benefit of affordable housing.
Yeah, I understand now. Thank you.
You're welcome.
Thank you. Thank you, Ms. Phillips.
Bye.
Yeah, letter T, he's unmuted though.
I purchased my unit, which is 31 Parkside last year.
That's 31 Parkside, and can we have your name, please?
My name is Ting Chen. Chen is my last name.
You're coming in very faint. Is there a way that you could speak louder or get closer to the microphone?
Can you hear me now better?
Yes, I can.
Okay. All right. Okay. My name is Ting Chen. I purchased my unit, which is 31 Parkside last year at market value. So when I purchased my property, obviously we did the title search. This thing didn't come up. As I read the summons I received, it says the recapture fee should be paid by the first sale. So my unit is actually from the original unit and then to a second party and immediately come to me. So I'm actually the third owner. So the first seller is actually also named in this suit. So I believe the recapture fee should be paid by the first sale, which is the first owner. So in my situation, what is the best solution for me? I did file with the court within the 35 days as as time is essence. So I did send in the paperwork, and I also hand deliver a letter to you, Sal, today
Yes.
to your office as well. So I just
So my office told me that.
what is the best approach in my situation?
Okay, so my office advised me today that we received a responsive pleading, and that must have been yours, Ms. Chen. Is that correct?
Yes.
Okay, so you've filed your answer, and you will be kept apprised of the developments in the litigation as it proceeds.
Okay. So do I need hire actual attorney, or what is the best?
I think the best bet for you, who represented you when you purchased your unit?
I did have an attorney, but now I have to pay like $375 per hour to get additional service.
Well, I think if you call your attorney, do you know who your attorney was?
Yes.
Who?
Lambo. Cindy Lambo or Jane Lambo.
Okay, I think if you call Ms. Lambo up and tell her that you've been served with this litigation and that the litigation says that a recapture fee is due on your sale of your unit when it was due from the original seller, and ask her to give me a call. I know if I were her, I would do that for you. I'd make that call. So why don't you call her, have her give me a call, and I can give her the answers you're asking for. Unfortunately, especially because you've answered, I really can't ethically give you those responses, and I apologize. I'm not trying to avoid you. Ask Ms. Lambo to call me.
Okay,
Okay.
all right, thank you.
Thank you, Ms. Chen. And Clara Don?
Yeah, my legal name is Chen Rudong, and I bought the unit 15 Cortland. And yes,
You just, and your address, please?
15 Cortland.
13 Cortland.
15
Cortland Lane, in December 2nd, 2019, at market price. My situation is very close to Miss Chen. I filed answer as well, and I'm going to represent myself. And I contacted the DeFazio's office a few times, and nobody, answered me. I don't think I need an attorney, right? According to the law, I could represent myself, right?
You have every right to represent yourself. If you have filed a pleading as a pro se defendant, then I am in a position to call you back, and you are on a list for those callbacks.
Okay. And also the seller is the EGNAC LLC, and he's supposed to pay. And he's also on the defendant list. What should I do now?
I can't give you advice, ma'am. But if you call me, I will try to answer your questions about the litigation as best I can.
When should I call you?
You're on a list in my office. I'm calling people back as best I can. If you don't hear from me by the middle of next week, you call me again, okay?
Okay.
But you're protected in the meantime. You've done what you filed that responsive pleading. And I will give you a call back.
Yeah, I have to protect myself.
Okay.
I feel like,
And this is Larry James Miller. And look, everyone has every legal right to protect themselves. And we urge everyone, if they feel that there's an issue that they dispute, absolutely take it through.
But from this whole lawsuit, what I feel that the people who benefit most are the lawyers, not the people, the affordable housing, people who are supposed to benefit from those, and not people like us, honest people bought for market price and didn't benefit anything. And we are now dragged into this lawsuit.
Ms. Don, the whole purposes of this lawsuit is to get money and redeploy it back into affordable housing for all.
Yeah, you can easily get the money from EGNAC family. He's the seller. He bought the units within the 30-year restriction period. Now, instead of after him, you're after, people like us.
And Ms. Don, I believe that Mr. DeFazio ran through that and explained the reason is that the lien runs with the property until it is satisfied. It does not run to the individual owners. So as Mr. DeFazio indicated earlier, he can get to the property and the current owner of that property. He can't get to the former owners who have since sold.
There should be a way before the units expired, right? The restriction period expired. The township should have a way to make sure they pay, not after it.
And that's the whole point of this process, is that there were units that sold and recapture fees were not paid. So it's clear that the title companies, the sellers and the buyers, weren't picking up the obligation to pay the recapture fee. This present declaratory judgment, if successful, and we have 100% or almost 100% certainty that will be successful, it will put the judgment on record so that anytime someone goes to sell, that they will have to satisfy that recapture fee obligation. Otherwise, the title companies won't insure it, the buyers won't buy it, and the lenders won't provide any loans until that obligation is satisfied and the judgment goes away.
Yeah, that's for the future. For present, we are the victims now.
Yes, and I agree, and that is, to some extent, Mr. DeFazio mentioned the litigation against the former BHHC attorneys, and that is proceeding on a separate track.
But if, the township win, what can I get back from it?
If the
The
township,
time, effort, money, and stress spent on this thing?
if we prevail or we resolve that matter, and in doing so, we recover the recapture fees that should have been paid on yours and other units, then you won't have to pay anything when you go to sell. As far as your question about the emotional distress and issues like that, I can't answer that. I can't give you legal advice. You can speak to counsel about that. It would be inappropriate for me to respond.
Okay, I see. Thank you.
Thank
You're
you.
welcome.
So there are no more hands being raised. Sal, can you give us any sort of sense of schedule right now? Sal, we're going to take you off mute.
Oh, I don't know how that happened. Okay. Well, earlier we had one resident who talked about how she didn't live in the unit and she didn't get service. And we have to resolve those problems. We have to get everybody served. We're working diligently on that. Once everybody is served and the time period runs, then the legal process will be ready for resolution by the court. And we'll take the necessary steps to get that done. So I'm hoping that, let's say we can get everybody served within the next 60 days. We would have to give them 35 days to respond after that. So you're probably talking 120 to 180 days out before we can actually go before the court on a motion for judgment to get this, to put an end to this. On the other litigation, that litigation is proceeding. That's quite a different track, obviously. That's negligence malpractice litigation, and that could take an extended period of time. The issue, Mayor, I think we as the township committee and the advisory boards and so forth, we should all talk about is what we do about residents who are in a position where they have to or want to sell before that issue has been resolved in terms of creation of an escrow or whatever. I think we need to come up with a plan with respect to that so that we can answer their questions when they pose them. But look, it's litigation. The unfortunate reality is that COVID has caused horrendous delays in the court system. Everything is pushed back. I think the BHHC declaratory judgment litigation, that's not a jury trial. That's something that will be resolved, I think, quickly. When the other case will be resolved, that could be a year and a half from now.
Okay. Well, thank you, Sal, for handling all the questions and for doing so with with patience. And I think there are a lot of folks who are upset. The litigation process is something that no one should have to go through, but the situation's brought us to this point. Doug, any final comments?
No, I just want to thank Sal and thank Heather and thank the residents for showing up. You know, we certainly understand the inconvenience here. We get it. But at the same time, we're a fiduciary for the program. So I hope the folks understand that. This is nothing personal. It's for the benefit of the program. Everybody that's currently going through it is getting the benefit of it. Let's make sure it's there for others.
Thank you, Mr. Mayor. Thank you, Doug. And thank you to all the residents. There were some insightful questions tonight. And I hope under the constraints that are imposed on me by the rules of ethics, I've done my best to answer. And I offer the opportunity to anybody who wants to have their counsel call me, please feel free to do so. And if you can't afford counsel, you were given the contact information for legal services in the summons and complaint, and feel free to contact them.
Great.
Thank
you.
Thank you. And with that, good night, everyone. Thank you.
Good night.